The Judiciary Act of 1789, an act to establish the judicial courts of the United States. Sec. 1. Be it enacted, that the Supreme Court of the United States shall consist of a Chief Justice and 5 Associate Justices, any 4 of whom shall be a quorum, and shall hold annually at the seat of government 2 sessions, the one commencing the first Monday of February, and the other the first Monday of August. That the Associate Justices shall have precedence according to the date of their commissions, or when the commissions of 2 or more of them bear the same date on the same day, according to their respective ages. Sec. 2. That the United States shall be, and they hereby are, divided into 13 districts, to be limited and called as follows. Sec. 3. That there be a court called a district court in each of the aforementioned districts, to consist of 1 judge, who shall reside in the district for which he is appointed, and shall be called a district judge, and shall hold annually 4 sessions. Sec. 4. That the beforementioned districts, except those of Maine and Kentucky, shall be divided into 3 circuits, and be called the Eastern, the Middle, and the Southern Circuit. T. That there shall be held annually in each district of said circuits 2 courts which shall be called circuit courts, and shall consist of any 2 justices of the Supreme Court and the district judge of such districts, any 2 of whom shall constitute quorum, provided that no district judge shall give a vote in any case of appeal or error from his own decision, but may assign the reasons of such his decision. Sec. 9. That the district court shall have, exclusively of the courts of the several states, cognizance of all crimes and offenses that shall be cognizable under the authority of the United States, committed within their respective districts, or upon the high seas, where no other punishment than whipping, not exceeding 30 stripes, a fine not exceeding $100, or a term of imprisonment not exceeding 6 months, is to be inflicted, and shall also have exclusive original cognizance of all civil cases of admiralty and maritime jurisdiction, including all seizures under laws of imposed navigation or trade of the United States, and shall also have cognizance, concurrent with the courts of the several states, or the circuit courts, as the case may be, of all causes where an alien sues for a tort only in violation of the law of nations or a treaty of the United States, and shall also have cognizance, concurrent as last mentioned, of all suits at common law where the United States sue, and the matter in dispute amounts, exclusive of costs, to the sum or value of $100, and shall also have jurisdiction exclusively of the courts of the several states, of all suits against consuls or vice-consuls, except for offenses above the description aforesaid, and the trial of issues, in fact, in the district courts, in all cases except civil causes of admiralty and maritime jurisdiction, shall be by jury. Sec. 11. That the circuit court shall have original cognizance, concurrent with the courts of the several states, of all suits of a civil nature at common law or in equity, where the matter in dispute exceeds, exclusive of costs, the sum or value of $500, and the United States are plaintiffs or petitioners, or an alien is a party, or the suit is between a citizen of the state where the suit is brought and a citizen of another state, and shall have exclusive cognizance of all crimes and offenses cognizable under the authority of the United States, except where this act otherwise provides, or the laws of the United States shall otherwise direct, and concur in jurisdiction with the district courts of crimes and offenses cognizable therein, and the circuit courts shall also have appellate jurisdiction from the district courts under the regulations and restrictions hereinafter provided. Sec. 13. That the Supreme Court shall have exclusive jurisdiction of all controversies of a civil nature, where a state is a party, except between a state and its citizens, and except also between the state and citizens of other states, or aliens, in which latter cases shall have original but not exclusive jurisdiction, and shall have exclusively all such jurisdiction of suits or proceedings against ambassadors or other public ministers, or their domestics, or domestic servants, as a court of law can have or exercise consistently with the law of nations. Original, but not exclusive jurisdiction of all suits brought by ambassadors or other public ministers, or in which a consul or vice-consul shall be a party, and the trial of issues, in fact, in the Supreme Court, and all actions at law against citizens of the United States shall be by jury. The Supreme Court shall also have appellate jurisdiction from the circuit courts and courts of the several states in the cases hereinafter specially provided for, and shall have power to issue writs of prohibition to the district courts when proceeding as courts of admiralty and maritime jurisdiction, and writs of mandamus, in cases warranted by the principle and usages of law, to any courts appointed or persons holding office under the authority of the United States. Sec. 25. that a final judgment or decree in any suit in the highest court of law or equity of a state in which a decision in the suit could be had, where is drawn in question the validity of a treaty or statute of or an authority exercised under the United States, and the decision is against their validity, or where is drawn in question the validity of a statute of or an authority exercised under any state on the ground of their being repugnant to the Constitution, treaties, or laws of the United States, and the decision is in favor of such their validity, or where is drawn in question the construction of any clause of the Constitution, or of a treaty, or statute of, or commission held under the United States, and the decision is against title, right, privilege, or exemption, specially set up or claimed by either party, under such clause of the said Constitution, treaty, statute, or commission, may be re-examined and reversed or affirmed in the Supreme Court of the United States upon writ of error, the citation being signed by the Chief Justice, or Judge or Chancellor of the Court rendering, or passing the judgment or decree complained of, or by a Justice of the Supreme Court of the United States, in the same manner and under the same regulations, and the writ shall have the same effect as if the judgment or decree complained of had been rendered or passed in a circuit court, and the proceedings upon the reversal shall also be the same, except that the Supreme Court, instead of remanding the cause for a final decision as before provided, may, at their discretion, if the cause shall have been once remanded before, proceed to a final decision of the same, and award execution. But no other error shall be assigned or regarded as a ground of reversal in any such case as aforesaid, than such as appears on the face of the record, and immediately respects the before-mentioned questions of validity or construction of the said Constitution, treaties, statutes, commissions, or authorities in dispute.